Attorney General.
Thank you very much, Mr. President. And it is my privilege to stand here to speak in support of the bill which has been presented before this Honourable Chamber by the Honourable Member for Diego Martin North East, the Honourable Minister of Finance. The bill is the Public Procurement and Disposal of Public Property Amendment and Validation Bill 2023, as amended in that other place last evening. I will not repeat the number of preambular sections, nor the sections which are there for consideration. I think the House is well aware of it all. I will get straight to the few points that I would like to make this evening. So, point one, with reference to one of the sections that arises for amendment, and that section arises for amendment under Clause 3 of the bill, and the section is Section 7. Point one that I wish to make, and to make very clearly, is that the government of Trinidad and Tobago has not acted illegally. There is an easy temptation to allow oneself to use that kind of language, but it is not permissible given the law as it exists, particularly with respect to the law of statutory interpretation. At the time that the two orders which are under consideration, the two ministerial orders, arose, Section 7, subsection 7 of the Act was clear. It is still clear. It is what we are here to amend tonight. And the fact of the matter is that the order that was asked for of the Minister of Finance under Section 7, subsection 6 of the Act did not require, on the literal interpretation of the law, an affirmative resolution. It's that simple. And the law is clear, and I spoke to it in the other house, and I will, at the risk of repetition, repeat it very briefly. The law is clear. It is not the job of those of us who are reading the law to change the law. The case of Belize, the Attorney General of Belize against British Telecoms, makes it very clear, and that is reported at 2009, 2 All England Reports 1132, makes it very clear that the law must be applied according to its literal meaning. Corrections of perceived defects are correctable by the legislature. And that is why we are in this chamber this evening. That is why we were in the other house yesterday. The government recognizing that there is an error in the law which it was not open to the government to change, either by the Attorney General or by the Minister of Finance, has come to this house and said, may we therefore change the law. So I repeat, the government has not acted illegally. Full stop. Secondly, I wish to turn to a principle which I consider to be of singular and pivotal importance in the discussion that we are having this evening, and that principle is the principle of the presumption of regularity. We are, and I speak here in the case of the Minister of Finance, and I speak in particular of the members of the government, are public servants, whether elected or appointed to public office, constitutional office, with the trust of the public reposed in us, and the principle of, or the presumption of regularity applies with full vigor. That presumption has been spoken to in many cases, but the best statement that I have read, and I have had the privilege to apply as a practitioner, was uttered by Justice of Appeal Clinton Bernard, as he then was at the time, in the case of the Attorney General and KC Confectionery, reported at 1985, 34 West Indian Reports, page 387, at pages 415 to 416 in particular. And I quote from Justice of Appeal Bernard: "The presumption of regularity is part of the law of this republic. The presumption is a salutary and sensible concept of government action. Were it to the contrary, great difficulty and burdens could arise in proof of the bona fide exercise of day-to-day executive action, and this could well lead to chaos or uncertainty. It is, with your permission, Mr. Deputy President, I continue to quote, it is, in my view, essential to our democratic system of government that confidence and trust," my learned colleague, Senator Lawrence Hislop, spoke of the trust. "It is, in my view, essential to our democratic system of government that confidence and trust must prima facie be reposed in public officials, and more particularly senior ones. The Minister of Finance is the most senior member of us here today, and in May and June of this year, when he was asked to issue the orders, which he did pursuant to Section 76E of the Act, he was acting on the presumption of regularity." And I continue to quote from Justice of Appeal Bernard: "It has never been considered to be morally right that one should condemn the whole for the misdeeds of a few. Hence, a presumption of regularity in their acts for which I contend. Public officials, as the term connotes, are people who render public service. The presumption can only be discharged by proof of mala fides on a balance of probability, so long as it can be demonstrated by evidence that the act of the public official or organ was a hostile act or an intentional and irresponsible act. That, in my view, will in fact be enough to rebut the presumption of regularity and to infer mala fides." So we are operating on the presumption of regularity, that at the point at which the ministerial orders were issued, they were issued by a senior public official in accordance with the literal law as it existed at the time, and there is no question of mala fides. Therefore, we are here to correct the law as it exists today and as it was amended last night in the House, and as we ask this chamber this evening, tonight, to improve on and to finalize that correction. Mr. Deputy President, let me move immediately to the two orders which were made, one on the 29th of May and one on the 29th of June 2022. But before I move there, permit me, Mr. Deputy President, to divert relevantly to another seminal treatise. The first, to which I have just spoken, is that of Mr. Justice of Appeal Bernard, and the second, to which I will now speak, is that of Mr. Justice of Appeal Telford Georges, a former Justice of Appeal of this country, a former Chief Justice of Tanzania, a former Chief Justice of the Bahamas, and a Justice of Appeal of almost all Commonwealth countries that we can think of, an esteemed and very respected judge of the Caribbean. He was asked, Mr. President, Mr. Vice President, on the 3rd of November 1999 by a special general meeting of the Law Association of Trinidad and Tobago to be the sole commissioner of inquiry because an imbroglio had arisen in this republic. The Attorney General then, the Honourable Ramesh Lawrence Maraj of the government, which is now in opposition, sought to impinge upon the independence of the judiciary, to refuse the then Chief Justice, Mr. Justice Michael de Labastide, going abroad because the Honourable Attorney General arrogated onto himself the right to control the finances of the judiciary. The Law Association, under the presidency of Mr. Carl Hudson Phillips, appointed Justice Georges to inquire into whether the Attorney General at the time was correct in law to have arrogated that power onto himself. And in examining the issue, which Mr. Justice Telford Georges ruled definitively that the Attorney General was wrong, one of the things that he did is he looked at the historical relationship between an Attorney General of Trinidad and Tobago and the judiciary. And it is for that reason I go there as I go to speak to the two notices. And at page 13 of his report, Mr. Deputy Speaker, is dated the 16th of February 2000. At page 16 of his report, with your leave, I quote, "Historically, the Attorney General has been the member of Cabinet responsible for bringing to the attention of Cabinet matters of concern to the judiciary. This is an inheritance from the pre-independence administrative structure. The Attorney General was a member of the Executive Council, the body in which time evolved onto the Cabinet." At page 20, he says, "I have spoken to the two recent holders of the office of the Attorney General, Mr. Keith Sobian and Mr. Russell Martin, OSC. Both were clear on the fact that they considered their roles as Attorney General to be that of conduits." Conduits, Mr. Deputy President, between the executive and the judiciary, because in our separation of powers, we have, as we know, a judiciary, an executive, and the parliament. And we like to speak about the separation of powers without understanding that there is not a rigidity between those three arms. There has to be a relationship amongst those three arms for the government to function. And the reason why the Attorney General has historically, from pre-independence, been the conduit between the executive and the judiciary is so that there can be a healthy conversation between two important arms of the state. In pursuance of that responsibility, I was approached as Attorney General of this Republic in late May of 2022 by the judiciary through its Chief Executive Officer, the Court Executive Administrator, and asked to deal with a matter urgently that had to do with the sequestration of a jury which was occurring within a matter of days. I took instructions and I approached the Minister of Finance. We discussed it, and it became necessary for the Minister of Finance to issue, on my advice, and I take responsibility for that, and I will come back to that. And I had a discussion with the Minister of Finance, and I said to the Minister of Finance, we need to provide urgently a ministerial order that will exempt the judiciary because they have a circumstance to deal with, among others. And it was in those circumstances that legal notice number 164 was drafted. When we look at legal notice number 164, we can see that what the minister did was to exempt the judiciary from the application of the Procurement Act, having regard to the operating contingencies that existed at that time, prompted in the first instance by the need to sequester a jury. What does sequestering a jury involve? It means that you have to bring a jury into a hotel or a place where they can stay. You have to feed, water, and provision them. You have to transport them from their home to the court, and you have to keep them locked into that hotel for as long as the trial takes place. There are circumstances in this country in which jurors are interfered with. They are threatened. You sometimes get into a taxi and you find a picture of your 5-year-old daughter on the seat that you are about to sit in, and the picture is torn because somebody's telling you that if you don't mind your business and do as the text message that you just got tells you to do, your children are in trouble. Those are the circumstances, Mr. Deputy President, in which the judiciary came to me and asked, can we get an urgent situation addressed? And in those circumstances, and there will be lots of talk about the fact, well, no jury was sequestered, etc. The fact of the matter is, it may not yet have happened, but at the time it was about to happen. And in the circumstances, that is why the exemption order says goods, services, and commodities arising from a court order. That is why it spoke in respect of goods, services, witness support systems, victim support services, matters involving experts. It went on to speak of goods, services, commodities related to psychological counseling, specialized devices, goods, works, and services required for the continuation of essential judicial or court-related services. Mr. Deputy President, the judiciary is a significant constitutional arm of the state that has its independence secured under the Constitution. And to require the judiciary, every time it has to deal with one of these exigencies, to have to go through the 30-day plus the standstill period of the Procurement Act is just absolute nonsense. It undermines the independence of the judiciary. It is contrary to the security arrangements that the judiciary requires to function, without which we may as well all go back to the jungle and stay in the treetops and shoot at each other with bows and arrows. The fact of the matter is, when we, and I spent some time in the other place going through the details of the very many services that the judiciary provides to this country. I'm not going to repeat all of it. Members can read the Hansard from yesterday and hear everything that I said and read everything that I said yesterday. The fact of the matter is, while the Act provides for national security services, it does not provide specifically for the very essential services that the judiciary must provide in circumstances that are comparable to issues of national security. And the circumstances which arose at the time required the urgency with which that exemption order had to be made. We go to the 29th of June. Last night we were informed, not for the first time, but it has to be repeated because persons love to speak convenient untruths as often as they possibly can in the hope that it will become the new reality. We were told yesterday, and we have been told before this, that the Heads of Government 50th Anniversary Conference had been shifted from Dominica to Trinidad and Tobago at the request of the Prime Minister of Dominica in late May. When was the order made? It was made in late June. When was the order made? The order was made, I beg your pardon, let me just pull it. 29th of June. So it was made in late May, so the order was made for the foreign heads of government 29th of June. The reality is that there was not the time for the 30 days and the standstill to be able to go through an entire process of going into Parliament and back to get that put together. On top of which, there were the exigencies operating at the time of the last minute confirmations of the visits of the President of Rwanda, the Secretary of State of the United States of America, Baroness Scotland of the Commonwealth Secretariat. All of those were being organized for Trinidad and Tobago at short notice, and there was no time. What does one do? Say, I beg your pardon, I'm very sorry, all of you stay home, we can't accommodate you. No. And that takes me, Mr. President, Mr. Deputy President, to Section 53 of our Constitution, which provides for peace, order, and good government. It is the responsibility of this government, never mind those others who have occupied the whole of government and have a different idea of how to run a country. It is the constitutional responsibility of this government to subscribe to and discharge its constitutional mandate for the peace, order, and good government of this country. And that is the basis on which this government functions. Mr. Vice President, we are here today when I wrote this note to myself. We are here in broad daylight. I wrote it at 2 o'clock this afternoon. It's now night, but we are not here at midnight on a Section 34. We came here in broad daylight in acknowledgement of the fact that we needed to amend the law in order to continue to govern this country for the peace, good order, and government of the country. And, beg your pardon, Mr. Deputy President.
Let us be aware of the standing order, which says that a member must speak in silence.
Thank you, Mr. Deputy President. And while we are on the natural, reflexive inclinations that they cannot help themselves with of those on the other side, while we are speaking about Section 34, let me make it very clear. Do not liken me to those other attorney generals who take kickbacks. I don't take kickbacks. So when you call names and you say some other attorney general would have given better advice, I don't accept that insult. And we are here, Mr. Deputy President. We are here, Mr. Deputy President.
We've all been here for a while, and we know the standing orders. As tempting as it is to increase any crosstalk, I ask that we conduct ourselves in manner and allow the speaker, once again, the contributor of the bill right now, to proceed in silence.
Thank you, Mr. Deputy President. We are here as a responsible government. We are not here to be judged by those who have chosen to descend to the bottom of the pit and to judge everybody else by their standards. We are operating on the presumption of regularity, and we are here in constitutional government. And Section 58A, which this House is being asked to affirm by the amendment that we asked for at Clause 4 of the legislation, of the bill before this House, introduces the concept of the threshold. We are asking this House to establish a threshold, 58A of the Act, subject to regulations made under Section 63. The procurement of goods and services up to $1 million are exempt from the procurement requirements under this Act. It says, subject to Section 63, which takes us next to Clause 5. Section 63 of the Act last night was amended, and I hear members here today on the other side speaking as if they have not read what was amended last night. The amendment that is before this House today on Section 63 is on the recommendation of the office or upon the initiative of the minister in consultation with the office. It's not the minister on his own who is going to do that which we are asking this House to approve. It is the minister on the recommendation of the Office of Public Procurement or in consultation with that office. So it's not a question of the minister on a frolic of his own. And we all acknowledge that the Office of Procurement Regulator is an independent office that is going to have the oversight of that threshold. And we know that under the section, the enabling section, which we are asking this House to amend, to approve the amendment of, regulations will be issued to speak to the manner in which that threshold will be operated in order to be subject to the scrutiny and the approval of the Office of Procurement Regulation. And let me get to perhaps the most critically important reason why we are here, in addition to the validation of the two notices to which I have already spoken, Mr. Deputy Speaker. Why are we here? We are here because some people in this country can't afford to have editorials written on their behalf. The little man and woman, children who have to go to school in September, who will have to get school books bought, uniforms bought, school fees paid, they need to be able to get the work that they are unable to get right now in the manner in which this act is being operationalized. It's as simple as that. That is the urgency. Children have to go to school. So we are here today to ask this House to approve the amendments which were passed yesterday evening in the House in order that the Act can operate consistently with Section 5, consistently with Section 5 of the existing law in order for efficiency, fairness, equity, and public confidence for all the citizens of this country. And we are not here to take any instructions from the elite who assemble on the 17th of June and hold up a meeting, and then conveniently it is reported, 17th of July, I have it here on my phone. It is and Senator Mark read for it, and I had it sent to me.
Yes, yes, your friends.
Media statement, several, it's dated the 20th of July, but it says, and when Senator Mark read from it, several private sector civil society organizations met on Monday, the 17th of July, 2023. Before we even went into the House, they had met, and they are condemning that which we are in the House to do, and they don't have the decency to acknowledge when it is published in today's papers that this is an issue that predated, a statement that predated what we are seeking to do today in the House. All we are being told is so-and-so has condemned what the government is doing, and the Prime Minister is being asked to tread carefully. Well, those...
Senators.
Why are you on screen?
Senators. Is a wait. Senators. Senator Mark. Senator Mark.
No, withdraw.
Senator Randall. Members on both sides. Members on both sides. From Senator Roberts, come down to Senator Mark. Please listen. The crosstalk and the chatter and the volume has gone too high. Kindly allow the Attorney General to make his contribution. I ask as my final warning whilst he speaks. Come hear your voice the loudest. Proceed.
Mr. Deputy Speaker.
For the record, I would still like to call Standing Order 46-4. There was a very offensive statement which was just made by Senator Mark, and it must not go unnoticed.
Senator Mark, your comments were inflammatory and it was out of place at the moment. No, Senator Mark. 46-4 upheld. Proceed.
Thank you very much, Mr. Deputy President. Mr. Vice President, beg your pardon. I was in the course of saying, before my remarks seemed to have troubled the other side sufficiently for them to rise in voice. I was in the course of saying, Mr. Vice President, that there is a vast number of persons in this country, they are referred to by the term small, medium business people. And we are talking about the plumbers and the electricians and persons who live and are entitled to live in exactly the same way as the rest of us live in order to be able to afford their school children's fees, in order to be able to afford to put bread on the table. And if we don't pass if we don't
Members, the level of disrespect being shown towards the Honourable AG as he's on his legs making his contribution leaves a lot to be desired. If it shall persist, I will ask one by one or collectively for individuals who continue to break our standing orders to take a break from each chamber. Proceed.
Thank you very much, Mr. Vice President. I was in the course of saying, and it was well put by Senator Dunarine in her comments. She spoke to the fact that the OPR system is not properly functional at this point in time. The operationalization of the law, now that, and Senator Dylan Remy used the term, now that the rubber has hit the road, Senator Vera talked about the difference between the academic view and the practicalities. Now that the law has been operationalized in the few months that it is in operation, we as a government, as a responsible government, recognize that we need to provide some flexibility to the operationalization of the law in order that everybody can get a fair, equitable share of the work that is out there that needs to be done. What is wrong with that? And that is why we are asking for the amendment by Section 58A to create a threshold level within which, not that people will have free operational license to do what they please, but within which, during this transitional period, while the Office of Procurement Regulator is getting itself better operationalized, while the procuring entities are getting their procurement officers organized so that people can be registered, we are asking this House to approve an amendment under the auspices and the oversight of the Office of the Procurement Regulator, working with the Minister to permit a $1 million threshold within which work can continue and people can earn a living. What is wrong with that? And why is it that we find the Guardian telling us that we are looking to repeal the entire act and to create for illegality? Those people who we are here today to give voice to earn a living can't get Guardian writing editorials for them. Beg your pardon. So we are here for them.
What's wrong with that?
Mr.
I use the word rubbish to describe that.
Mr. Vice President, the other point that I wish to come to is with respect to the two amendments to be made, both with respect to Section 7 and with respect to Section 63. I've already spoken to the fact that we are asking for an amendment for the services to be on the recommendation of the office or on the initiative of the minister in consultation with the office by order may determine the exemptions that he grants. But the important point that I now want to turn to is that which has troubled, and I can understand, that which has troubled certainly the independent senators, the shift that we are making from affirmative to negative resolution. The short point is, two short points, Mr. President, Mr. Vice President. The negative resolution process does not remove the orders made by the minister if the amendments are approved from the oversight scrutiny of the House. Section 75, subsection 7 of the Interpretation Act, if I may read, the subject to negative resolution of Parliament shall, as soon as may be after they are made, but within the prescribed period, be laid before each House of Parliament, where either House within the prescribed period resolves that any of those instruments or documents shall be annulled, that instrument or document is void as from the date of its resolution, but without prejudice to the validity of anything done thereunder or to the making of a new instrument or document. Thank you. 2 points there. The negative resolution will be approving an order that has been made pursuant to the amended Section 7 and the amended Section 63 with the oversight of the Office of Procurement Regulator working with the minister. That's the first point. So there's oversight on that. And then it is lodged with both houses. And if within the prescribed period, any of the members of either of those houses, whether they be independent or opposition, wish to call in question what has been done, you file a motion to annul. And as indeed one of our members here today reminded us, we were here not too long ago on Senator Mark's motion. We fully debated the negative resolution on that which had been brought here by, I almost said by the OWTU. It hadn't been brought by the OWTU, but it certainly had been lobbied for by the OWTU. And we had a full debate so that the amendments that we are seeking to make to allow the minister to make orders pursuant to Section 7(6)(e) will be under the oversight of the Office of the Procurement Regulator and the oversight of Parliament on the negative resolution procedure. And may I, as I close, Mr. President, may I, as I close, say a few further words. That is to say, that I would like to acknowledge the contributions, and I find it a pleasure to do that every time I stand in this Senate. I would like to acknowledge the contributions that have come from the independent bench. I have listened carefully to Senator Vera. I have listened carefully to Senator Richards, Senator Dionarine, Senator Dylan Remy, and Senator Sipasad. They've all made valuable contributions, most of which we can work with. I will leave it for the minister in his wind-up to address that. But the short point that I make is that given the clear evidence that has been presented in this debate in the other house and what is out in the public domain, I would exhort our independent senators, when the time comes to vote, to remember that there are a category of persons in the small and medium category of citizens who deserve the equity that Section 5 of this legislation offers to them. And with those words, Mr. Vice President, I support this bill. Thank you.
Members.